basis of necessity and state practice, coupled with compelling reasons, immunity ratione personae should not be abruptly extended beyond the Troika. The Commission needs to be cautious in adopting a liberal approach that would extend the boundaries of this exception. I just want to, I don't know whether this is appropriate time for ALCO to express its opinion at ILC, because I wish to learn, when I heard Iran, I think they are in favor of Troika Plus. Maybe we need to hear more member states before ALCO could take a position at the international forum. That's my point. Thank you, Madam.
Thank you very much. Is your intervention for this subject over, or you would like to make your statement now? It's over?
I think the statement, you said that there is
I think if there are no more questions from the floor, we would go to the formal statements. So would India like to continue with their statement? Okay, I'll give the floor to Japan first and then...
No, well, I mean, okay.
Madam President, thank you very much. I appreciated greatly the very informative, detailed, up-to-date explanation and views on the work of ILC by the three eminent panelists. Madam President, first of all, I'd like to, at the outset of my remarks on the work of ILC, I consider as my duty, both official and personal, to refer to, with great sorrow, over the passing in March this year of Ambassador Chusei Yamada, who has been well known among many here by his long-term dedicated service as a member of the ILC from 1992 to 2009, and as a delegate for Japan to the ALCO for 14 years, from 1993 to 2007. As a member of the ILC, the late Ambassador Yamada served as chairperson during the 52nd session in the year 2000, and in 2002, he was appointed Special Rapporteur on the Shared Natural Resources and completed drafting of the articles on the law on transboundary aquifers. As delegate to the ALCO, he regularly participated in its annual meetings and contributed greatly to deepening the discussions on the agenda of ILC in particular. During the first session of ILC this year, on the third day, 8th May, I understand a memorial session of Ambassador Yamada was especially held, and as many as 16 members of the Commission delivered their personal remarks praising his contribution to the work of ILC as excellent international law scholar as well as experienced diplomatic practitioner. Madam President, the provisional agenda of the forthcoming session of the UN General Assembly includes, among others, the law of transboundary aquifers, and the question of draft articles of the law of the transboundary aquifers will be considered by the Sixth Committee of the General Assembly under its resolution 66/104. Against the background of rapid social and economic development and population growth in the developing countries, the demand for resources is dramatically increasing, and in particular, the appropriate management of underground water is essential to the realization of sustainable development. Transboundary underground water exists all over the world. Therefore, to establish a legal framework thereupon is of vital importance to avoid disputes among the states concerned and to keep the stability of the region. From such viewpoint, the draft articles adopted by the ILC could serve as a useful platform for managing regional underground aquifers. The UNGA resolution adopted in 2008 encourages the states concerned to take into account the provisions of these draft articles in making appropriate bilateral or regional arrangements for the management of their transboundary aquifers. The draft articles reflect the wide range of the state practices and scientific grounds which have been proven in cooperation with UNESCO and other special agencies. Throughout the deliberations of the Sixth Committee in 2008 and 2011, many countries referred to the usefulness of those draft articles. Japan considers the draft articles are outcome of the codification and progressive development of international law and should be taken into account widely in making bilateral and regional agreements, and will actively participate in the discussion of the Sixth Committee. Japan, in its note submitted to the Secretary General, called for declaring the draft articles as the guiding principles. To the Asian and African states, the appropriate management of water resources is a great task to realize their development and stabilization of society, and the draft articles are useful instruments to both regions. In the course of discussions in the Sixth Committee, some water resource scarce countries expressed concerns on the draft articles, but they will certainly be a useful legal framework for the appropriate management of groundwater, and thereby would guarantee access to groundwater for resource-scarce countries. Japan wishes to get the cooperation of as many countries as possible. Madam President, Japan welcomes that the ILC decided to include the topic protection of the atmosphere in its work program and designated Dr. Shinya Murase as a special rapporteur for that topic. Japan believes that ILC has a large role to play in the area of protecting the atmosphere, and the international community needs to make concerted efforts to that end. We hope earnestly that through consideration of the topic, ILC will sort out various issues relating to the subject and avail itself of the opportunity to contribute to the codification and progressive development of international law. As the protection of the atmosphere is a great task confronting the Asian and African regions, we earnestly hope that the ARCO member states contribute actively to the deliberation on that question at the ILC. Madam President, ILC in its work to make a worthwhile contribution to the codification and progressive development of international law needs the input from the widest range of the international community, in particular from the Asian and African states. To that end, the ALCO has an important role to play. There are two ways of ALCO member states to contribute to codification and progressive development of international law. One is by presenting comments in reply to inquiries. Another, making statements during the deliberations at the Sixth Committee. We would like to see the ALCO member states to make utmost use of these opportunities and actively participate in those important communications with the ILC. Thank you, Madam Chairman.
Thank you, Japan, for your statement. I'll now give the floor to Thailand. You have the floor, sir.
Madam President, distinguished delegates, my delegation would like to express our appreciation to the speakers for their presentation, which have provided us with the overall picture of the ILC issue under consideration. Also, we wish to thank ALCO for organizing this special half-day meeting on selected items on the agenda of the International Law Commission, and to thank ALCO Secretariat for preparing a report of excellent quality on related matters. Madam President, while there are many topics on the agenda of the ILC, the selected topics to be discussed in details are indeed of particular concern for various ALCO member states. This delegation would like to make a few comments in this regard. On the protection of persons in the event of disaster, it is recognized that people's lives need to be protected on the one hand, and that appropriate procedure must be put in place for the necessary operation to be conducted effectively on the other hand. At the same time, even in the event of disaster, one cannot choose to ignore the important and often highly sensitive issue of state sovereignty. Therefore, we need to strike a right balance between the two principles under the specific circumstances of each case. Madam President, the Royal Thai government has taken a progressive view regarding disaster management and prevention. There has been a series of 4-year plans to deal with various forms of potential disaster, with water management being the latest. From monitoring and early warning system to responses and recovery measures, our process is already based upon the principle of preparedness and risk reduction. In any case, while we have such active strategy in place, we also recognize that determining the national response capacity of a state in a process that may affect certain core principles, be they sovereignty, territorial integrity, or non-intervention. Thus, it will not be an easy task to alleviate the concern of state on this point. My delegation is of the view that the nature of state sovereignty in this context encompasses both rights and obligations. That is to say, while a state affected by disaster indeed needs to ensure that its national and others within its territory are given assistance, this does not mean that all of the necessary components of its sovereignty are to be disregarded. Madam President, on the immunity of state officials from foreign criminal jurisdiction, this delegation commends the work of the Commission on this topic, which clarifies the question concerning immunity of state officials, in particular immunity before domestic court of other states. To this effect, the work will assist the international community seeking ways to fight against international crimes and to bring perpetrators to justice. My delegation also observed the scope of the immunity rationale personnel needs to be comprehensively analyzed in light of strengthening the rule of law and eliminating impunity. Also, the ambit of immunity rationale material should be formulated with the view to establishing a possible exception of immunity in the context of international crimes. Finally, I now turn to the last item on my list, the expulsion of aliens. One cannot deny that it is a sovereign prerogative of a state to regulate the presence of foreigners on its territory. However, it has also been established that such a power may not be exercised with no limitation, particularly where human rights are concerned. Safeguards need to be put in place in order to ensure proper conduct in this area. While a state may be concerned with ridding itself of further problems from particular individuals, it cannot turn a blind eye on the potential violation of human rights and the consequences from the expulsion of aliens in certain circumstances. Ensuring a fair and transparent procedure of expulsion would at least lead to a more substantive protection against arbitrariness and maltreatment. In this regard, states are bound to respect the right to life and at the least physical integrity. Also, expulsion should not lead to cruel, inhumane, or degrading treatment. Madam President, on the formation and evidence of customary international law, our member state needs to compile evidence of their state practice and opinion jurists on the ILC agenda, as well as to answer questions posed by the ILC. This is to ensure that ALCO plays a role